So I'll do an introduction. So this is Riverside County Law Library's virtual resource fair featuring speakers from Inland County's Legal Services, Inland Empire Latino Lawyers Association, Riverside Superior Court Self-Help, and the Riverside County's Department of Child Support Services. You are all in listen-only mode and can use the chat and Q&A feature to ask questions. You can access those at the bottom of your screen. There should be a toolbar that pops up. We are recording, and the recording will be made available about a week after this presentation. And so first we have Veronica Garcia from the Inland Empire Latino Lawyer Association, also known as IALA.
Good morning, everyone, and hold on just a moment while I get my PowerPoint up. All right. Okay, here, hopefully everybody can see my screen. And
I can see it.
Okay, perfect. So thank you everybody for being with us today, and thank you to Riverside Law Library for putting this together. My name is Veronica Garcia, and I'm with Inland Empire Latino Lawyers Association, more frequently called IALA. And IALA is a nonprofit organization that provides free legal services to the underserved residents of Riverside and San Bernardino counties. And there's just a few introductory things I'd like to mention. Excuse me. Just a few barriers that come to clients who are representing themselves when dealing with the legal system. Oftentimes it can be kind of overwhelming. There's a lot of complicated forms, procedures, terms that you may not be familiar with or have never heard before. And then it's additionally intimidating if the opposing counsel does have an attorney representing them. So our goal is to try to help overcome some of these barriers and help prepare pro per litigants to represent themselves in the court, and also to help them with the paperwork process. And there's various levels of legal assistance you can receive, and those range from, on your left, self-representation, maybe doing everything yourself, and then over there on the right, to formal representation, which would be hiring an attorney and basically having the attorney take the reins and do most of the communication and the legwork for you. We fall somewhere in between. We offer predominantly self-help plus advice. So we do have paralegals who prepare the documents and offer limited services. And then you do receive advice on your issue from our attorneys. Now, just above that would be pro bono representation from other non-legal aid organizations. And then, of course, representation from legal aid organizations, which is a service we also offer in certain types of cases. And now some of the areas that we are able to offer assistance include family law. There's civil law in terms of limited civil cases, and I'll get into that in just a little bit. And then also name change applications. One of our newest areas that we've begun offering services is in the area of guardianships and limited conservatorships. And again, I'll get into that in a little bit. And then, of course, with landlord tenant law. And this can be COVID or non-COVID related, since I know housing issues are a big problem right now with the high unemployment and people being out of work. It brought up a lot of new concerns, and we're trying to stay on top of the evolving laws relating to that area. One of our areas that I'm going to get into in a bit of detail would be related to our record clearing services. And then last but not least, we do offer extended services for teen parents. And to get into the services we offer for family law, this is kind of a general term that refers to matters concerning a marital relationship or domestic partnership. Paternity or parentage is a relationship between parents and children. And then we also assist with any sort of domestic violence between family or close friends. Other issues that fall into those categories include child support, child visitation, restraining orders, and then modification of any existing orders. One of the things we do ask, if you do have existing orders and maybe you had an attorney in the past, is that we do require to see all of your existing documents. And then also, if you did have an attorney, we do require that attorney substitute out, which basically means they're telling the court that they're no longer representing you. And that way we know that we have the legal authority to offer you advice on your case. And then the last thing would be division of assets and assignment of debts. And that essentially comes in a divorce. So those are things we can help you with and try to assess what, if anything, you're entitled to, and then try to figure out what strategy you want to take to move forward. Now, in the area of guardianships and limited conservatorships, as I mentioned, this is kind of a new area for us offering services. It is a little more complicated. We do have to get a lot of information from our clients, but it's just because of the nature of the action. So when you're applying for guardianship, it's generally for minors who are not under the jurisdiction of Department of Children and Family Services. So that's also referred to as CPS. Most common are cases where maybe a relative or close friend has entrusted you with the care of their children. Sometimes this can be due to incarceration. Maybe it can just be due to some concern for the child's safety, care, or welfare. Maybe somebody recently became homeless and they have children and they've asked you to help them care for their child while they get back on their feet. So this does not terminate parental rights. It merely pauses it. So it's something that can come in handy. Maybe you're a grandparent who's helping to care for your grandchild. It does give you those legal rights that a parent would have. So say you need to enroll the child in school, or maybe you need to authorize some sort of medical care. That's where it's very important, because if you don't have the parent at hand and you don't have a quick communication with them, if some emergency were to arise, this is where guardianship can be really helpful. Limited conservatorships are often referred to us by Inland Regional Center. And what these are for is a court arrangement where the conservator cares for and protects a developmentally disabled adult. And this is going to be to provide for their daily needs. And we call it limited conservatorship, or the court refers to it as limited conservatorship because it's not generally related to an estate. Oftentimes, if you contact somebody who handles conservatorships, they're referring to maybe older adults who have substantial assets. Maybe they have, a trust and maybe homes and bank accounts. In those cases, it's going to be more of a conservatorship of the estate. And in cases involving disabled adults, it's more for the care and not necessarily their assets, because 9 out of 10 times, those people who qualify for our services, obviously their children or now adult children, don't necessarily have assets to where they would need conservatorship of the estate. And relating to civil law, some of the things we're able to assist with are collections defense, demand letters, wage garnishments. This is most commonly related to old credit card debt. I think that's where we see a majority of our cases. And then next we have landlord tenant law. So this is an area where we actually are able to offer full representation. So if you're served with an unlawful detainer, and what an unlawful detainer is your landlord evicting you. Now, there's a few steps that a landlord has to complete before they move forward with an eviction. So the landlord just giving you the 60-day notice or 30-day notice, that's the first step. Now, when they actually go to court and they serve you with a summons, that's when it turns into an unlawful detainer, and that's when it's very important that you respond as soon as possible. Legally, you have 5 days from the time you're served to respond. So it is very important that you contact an attorney, whether us, ICLS, or another private attorney, in order to move forward with a defense against that unlawful detainer. And again, we are able to offer full representation. So that means signing on as your attorney and then taking the court or taking the ability to represent you in court. And we do offer COVID-19 specific advice. Our attorneys try to stay up to date on the ever-changing laws. Obviously, the other day we had another extension of the eviction moratorium. And if you're confused about what that means for you, or if you think that it maybe applies to you, then definitely give us a call and we can set up an appointment for you to talk to one of our attorneys. Now, the next program is called our One Step Further program. And this is specifically designed for teen parents. And what this program includes most often are educational presentations. So obviously this was pre-COVID, and what we were able to do is offer a variety of services to clients who are under the age of 19. So this does require that you be a teen parent. You have to have a parent or guardian consent. And if you're under 18, then it would verify, or I apologize, we would qualify you based on your parent or guardian's income. Now, with this, we offer document preparation in those same areas of law I talked about before. Often it's related to a child, maybe to establish paternity, you're having issues with visitation or custody, but there's other areas as well. So one that's less common is probably relating to a living trust or relating to a will. Maybe you want to make sure that your wishes are carried out if something were to happen to you relating to your child. And again, this is an area where we are able to offer extended services and full court representation if you qualify under our One Step Further program. Now, this next program is going to be related to record clearing. And today there's likely to be a bit of overlap when it comes to the services offered. So I did want to highlight one of our unique programs that has a little bit different focus than some of the other agencies that are going to be presenting. While many of our services are focused on assisting individuals or addressing an issue within one home or one family, I really do feel strongly that this program really does help benefit society as a whole. I think that helping to clear somebody's record does a lot to promote and encourage everyone to become productive, to be able to become their best and, really aspire for jobs that maybe they didn't apply for before, because one of those barriers of being justice involved is having that fear of what's going to come up on a background check. And it does make it hard to move forward. And I feel that this really does allow people to live up to their potential and to really kind of set their heights, set their goals higher than they would have with that, the burden hanging over them. And some of those programs here are expungements, early termination of probation, certificates of rehabilitation, request to seal of juvenile records, and then most recently, just as of January 1st, is AB 2147. And what that is that offers expungement options for those who did prison time, but were sentenced to a state fire camp. So those would be people who were at the Conservation Corps and ended up fighting fires, alongside with CAL FIRE and other fire agencies. Now, here's a little, just a fun pop quiz. And this is something that's obviously totally informal. And just to give you some numbers, how many formerly incarcerated individuals are in California? And I'm sure there's a lot of guesses out there about, how many people have had some sort of incarceration, and maybe that ranges from time in prison. Maybe it could be, just a night in jail after a DUI. And one of the surprising things here, obviously everyone has a guess, but the number here is actually 8 million people. Now, these numbers are from a study in 2015, so they're actually probably significantly higher now. And at the time of the study, let's see here, the next question is going to be nationally, how many people have a criminal record? And this one is another pretty shocking number. It's over 70 million. And again, this is from 2015. That comes to 1 out of every 3 adults. And a way to kind of put that in perspective is that means that in the US, we roughly have the same number of people with a criminal record as we have with 4-year college graduates. So, I mean, it's something that a lot of people, maybe there's some hesitation to ask for help regarding these issues because people don't necessarily know that you have something in your past. And, we recently had a client like that to where she didn't have anybody to complete her proof of service because nobody in her life knew about this past conviction from 15, 20 years ago. So obviously that's somewhere where we can step in and help out a little more to fill in that gap so that she doesn't have to essentially out herself to the people in her life now who aren't aware of that history. Kind of helps her move forward in a true, complete clean record fashion. So some of the things that you do need if you're in need of an expungement or any of those other record clearing services Include a rap sheet. Now, the picture here on the right is a quick example of a rap sheet. And obviously everything's been redacted, so you don't see any personal information here. It is something that you can request from the Department of Justice. And we do have information on how to get your rap sheet if you're interested. And maybe, you're not sure if you had, an arrest back in, 20 years ago. This is going to be the easiest and most inclusive way to find out what charges are actually on your rap sheet and what people would see on a background check. Now, this has all of the case numbers, the sentencing terms, conviction date, and those are all things that we need in order to fill out the documents to request an expungement. Another option you have is individual case summaries for each conviction. Now, these are things you can get from each court, and they sometimes have all the information we need. Sometimes we do have to have you follow up with the court to get something else. But for the most part, either one of those options is going to be what we would need to move forward with your case. Now, a little bit about what an expungement actually is. It's often also referred to as a dismissal. And that does give a little bit of some confusion sometimes, because even though a case is dismissed, it doesn't mean that it's completely erased from your record or erased from the court's files. Here are some of the just technical penal codes for some of these options we have in seeking an expungement. And it really has to do with what you were sentenced with. So that's where that case summary is important, or the rap sheet, because it does show us what your sentence was, and then we can figure out which option is best for you. There's a few exceptions, obviously, and we'll get into some of those in just a moment. Relating to qualifications, we generally request that you have all of your fines, fees, and restitution paid. Fines and fees are mandatory. Restitution we have seen where the district attorney's office did file a motion to essentially, they disagreed with the request because restitution had not been paid. And then, of course, you have to complete all of your probation terms, so you cannot be on active probation. A few things that would disqualify you from an expungement would generally be state prison. There are some exceptions to this, so that's where it is important that you contact us if you think that you're interested in these services, because we would assess each individual case and let you know what the options are for that each case. Now, of course, state prison, there's caveats here, unless it can be reduced to a misdemeanor. So there's something that's called realignment under AB 109. What they did is they changed the sentencing terms for a lot of criminal offenses. So there's a very long list of offenses that they decided were no longer eligible to be served time in prison, and that if you're convicted of those offenses, you should serve time in county jail. So if you went to prison before they made the realignment, before they made the changes, then you might be qualified for an expungement, even though you did go to prison for that offense. Another disqualification would be if you've served less than 1 year since your conviction, and it was a non-probation case. So maybe your case was closed 6 months ago and you didn't get any form of probation. Well, then you're required to wait 1 full calendar year. So you would have to wait another 6 months. Another disqualification would be traffic tickets. There's exceptions to that, of course, because obviously, if you were to get a DUI, that's a little bit more than a traffic ticket. But if it's just for driving offenses, moving violations, those would not be eligible for expungement. And then felony sex crimes are also disqualifications from the expungement process. Now, a little bit about the effect of an expungement. This is where, so you can answer no to the question if you've ever been convicted of a felony or misdemeanor. And what this is, the importance of this relates to being offered a job. Now, California does have legislation relating to ban the box. It was a few years ago, where they can no longer ask, an employer shouldn't be asking you if you have a conviction for a felony or misdemeanor. That shouldn't be nowhere on the application. But they can ask you once they offer you a conditional job offer. So at that point, now say no. If you have an expungement granted, you'd be able to honestly let them know that no, you do not. Alternatively, and what some clients choose to do, especially if they have a number of convictions that are expunged from their record, they opt to say that the case was dismissed. We do recommend that people keep a copy of their dismissal and their updated case summary when applying for jobs, just in case the background company comes up with something that maybe hasn't been updated. We want to make sure that you're in the right and you're not seen as giving false information. So having that to back you up does support that ability to say no. Now, of course, this does open doors to employment opportunities. Employment is obviously still discretionary based on qualifications required by employers. And there are some exceptions to where it does not qualify or does not apply. If you're applying for certain licensing or state jobs, say example, you want to be a police officer, those are still going to come up. And the effect of the expungement is not that you can just say, no, it didn't happen. Now you'd have to apply and give them the information on the offense, and then they look a little bit further into how it correlates to the job and want some details on that. So there, the most important thing is honesty, of course. Now, next types of offenses were related to marijuana. Obviously, there's been some changes in California in the last few years, and there is a different set of forms for cases involving marijuana for older convictions. So again, this is one of those case-specific areas where if you do have a marijuana offense, definitely get in contact with us and we can assist you with getting that removed from your record. And that's not quite an expungement, but it is removed from your record. Now, the next area of services would be early termination of probation. And this is something that is very case-specific. If granted, it would terminate your probation before the end of your original term. So if you are charged with, let's say, assault with a deadly weapon, but you do not receive any prison time and the court grants you 3 years of probation, well, maybe you complete 2 years of probation, you completed your classes, you paid your fees, you went above and beyond, you went to counseling, you made the changes necessary to show the court that you learned from your mistake, to show the court that the person you were or the decisions you made did not define you, and you're now moving on from that. And you really do have to present that evidence to the court, showing what changes you made and how the court should view these changes, and that you no longer need this mandatory supervision. And again, this is done on a case-by-case basis, mainly because the court does request a lot of information. They really want to see that evidence from you. This is done again, you give that compelling reason. And it qualifies you for expungement, of course, assuming your fees and fines are paid off, because you'd no longer be on probation once probation is terminated. Now, the next type of rehabilitation would be the certificate of rehabilitation. And what this is, it's necessary when you're not eligible for an expungement. So say you went to prison and your conviction does not fall under those realignment exceptions. Well, this is when a certificate of rehabilitation is going to be helpful. It serves as a similar effect as a expungement. Sometimes I feel like it might be a little bit stronger because you really do have to show more evidence, similar to the motion for early termination of probation. This is going to be when you served a prison sentence that's not eligible under realignment, and if granted, it automatically also triggers an application for a governor's pardon. And governor's pardons are a little bit less frequent to be granted, but it is the only option you have if you're looking to restore gun rights or additional other rights in California. Now, what do you need to apply to a certificate of rehabilitation? One of the main things is time. So the period is a little bit different. The clock starts running when you're discharged from prison or you're released from probation or parole. Now, the waiting period is what's important. So you do have to have both 5 years of residency in California. Now, keep in mind, this means that you have to have continuous residency. So let's say you were released from prison in 2000 and you moved to Arizona for a few years, and now you're back in California. Well, as long as you've been back here more than 5 years, then you would have that time requirement satisfied. Now, let's say you were released in 2011 And so you're at your 10 years since you've been released, but you've been in Arizona for the last 7 years. Well, now you're going to have to wait a few more to meet that 5-year residency requirement. There's also a waiting period. Each offense has a different waiting period. So for sex offenses, it's generally 10 years. For other types of offenses, there's another exception for 9 years. Most common is going to be 7. So 7 years is probably what we see most frequently. Now, keep in mind, that's going to be from the time that you are released or released from probation or parole. And for these, we do request that you get some substantial supporting documents. Generally, having 3 letters of recommendation or character letters is very helpful. And these can be from a number of types of people in your life. Maybe it's from a past employer, a current employer, maybe from a coworker or a friend from church, a friend from some type of group you're involved in, someone who has the ability to convey to the court how they've seen you change. This can be from family members, maybe children, if you were, out of their life for a period of time, and now you've returned back into their life and they've really seen the changes that you've made in the past few years. That can be very impactful to the court. Something else would be any sort of proof of education, school certificates, degrees. This doesn't necessarily have to be formal. Maybe you're taking some sort of online courses. Maybe you're taking some sort of self-enrichment just to where you're bettering yourself for your own personal peace of mind. And then, of course, any completion of drug and alcohol programs, counseling, domestic violence classes, all of those are going to be helpful to show the court, evidence that you've made these changes. And next is related to the pardon. So again, this is something that you automatically are applied for once you have a certificate of rehabilitation approved. And if granted, the pardon has the ability to restore a few rights. Obviously, the most common one we hear, people interested in restoring their firearm rights. So this is related to certain types of convictions. You can have firearm rights restored. Ability to serve as a county probation officer or parole agent. Obviously, certain sex offenses can then be relieved of the duty to register. And then something that may not be as exciting, but you'd have the ability to serve on a jury as well. Now, these are some things that a pardon does not do. It does not seal or erase a conviction. It does allow you to say that there's no record of the conviction. And I apologize, it does not allow you to say that there's no record of the conviction. You are still going to have to admit to that conviction, but having a pardon is essentially having a big eraser or a big marker and putting an X through it. It's there, people can see it if they run a background check, but you've been pardoned. Something else that it would not do is it does not restore firearm rights for certain types of offenses. So if you had an offense that involved dangerous weapons, well, then this would not be something that would just give you those weapon privileges back. And then again, it does not pardon state or federal convictions. And it does not intervene in any sort of deportation hearings or process. So unfortunately, it would still be something that can be used in any deportation hearings. And something we see a little less frequently would be requests to seal juvenile records. Obviously, this is less common because there have been some changes to the law, and many are now automatically sealed after a juvenile reaches the age of 18. So there are sometimes we see this with limited situations where maybe somebody's in their 30s and they have something that came up in a background check and they want to make sure that it is sealed. So just a little bit about how we operate our clinics. At Ayala, all of our clients have to fall below the 200% of federal poverty guidelines. We do have a few exceptions to this when it comes to our expungement program. Relating to record clearing services, we have some grantors who allow us to take clients that do surpass that amount. So again, I would recommend you, or if you know anybody interested in those services, contact us for that one-on-one consultation and assessment so we can determine if we're able to assist. Our goal really is to provide quality legal assistance to all of our clients within 1 week of qualifying. There are some scheduling exceptions, of course. Trying to work out everything remotely has been a challenge, but we feel like we're getting a good hang of it. We do rely on pro bono attorneys who volunteer 100% of their time. 100% of their time with us is on a voluntary basis, and it's pro bono, so they don't charge anybody, and then they receive no compensation for us, of course, other than our appreciation and recognition. All IALA volunteers are trained in the areas of law that they're providing services. They may not necessarily practice in that area, but they do receive training and are supervised by staff attorneys. And a little bit more into the technical process, how it all works now. Since before COVID, we were in person. You had to come down and wait in line and fill out your papers with a pencil. Now we do everything online. So that's something that's very exciting for us. I think it really gives us an opportunity to serve people who maybe we wouldn't have been able to serve before. And that's just not geographically, but also schedules. I mean, if we have a clinic at 2 p.m. on a Wednesday, a lot of people who need our help can't necessarily make it to those clinics. So now you can email us at midnight. We'll get it the next morning and get back in contact with you and move forward from there. So all of our pre-screening, income, and residency requirements, those are obtained via an online intake form. There's then a client intake interview. So there is one form that you'll fill out online, and then we follow up with a phone call or email to clarify any information and let you know whether or not you're qualified. From there, then you'll speak with one of our pro bono attorneys or one of our staff attorneys via the phone or Zoom. So essentially, everything is done from the comfort of your own home, or maybe your car or work, wherever it is you're at, we're able to assist you. One of the things that's, I think, important is that even after you have that initial contact with our pro bono attorneys, our staff does remain available to kind of answer any sort of follow-up questions, because again, you are still pro per, which means you are representing yourself. But we do want to make sure that there's not a lot of confusion for you, and we want to make sure that we're addressing any of those potential confusions and helping you understand where you're at in the process and what you need to do, rather than just sending you to the wolves. And some things you can expect to receive during your consultation. Obviously, legal advice is something that you can only receive from an attorney. So a paralegal cannot offer you legal advice. They can give you advice on the procedure, like the actual process of what you need to do to file or where you need to sign, things like that. But in terms of the best course of action related to your case, that's something that you do need to speak with an attorney to make your final determination of how you're going to move forward. And then the document preparation. So we do all of the forms for you. So if you maybe have, maybe you're starting a divorce and you've already started the paperwork, and you just want to have somebody review it, unfortunately, you can always send it to us, but unfortunately, we would not utilize that same paperwork. We would prepare it, and then, of course, send you your original paperwork back, and then have you review the paperwork that we prepared for you. And then something that I think is really neat, and hopefully other counties will move toward offering it in the future, Riverside County offers free e-filing for their clients. And so this is something that we can assist you with if you're in Riverside County. If you're in San Bernardino or some of the other counties surrounding us, then unfortunately you will still have to file in person. And a lot of them, due to COVID, are using drop boxes and other sorts of options. I know I saw that Los Angeles in certain types of cases has email filing. So that was something interesting. And, again, hopefully we'll see, with COVID, that people start to offer this on a regular basis, even after, we move toward having things in person again. Now, in terms of what some of our requirements are, it's pretty simple. The first thing is just going to be that you be a resident of San Bernardino or Riverside County. And we do not have a Riverside or San Bernardino timeline in terms of how long you have to be a resident. You could have just moved here yesterday and we would be able to assist you. Excuse me. Now, the court has different restrictions and requirements, so it will be dependent on what type of case you have, whether or not that's going to be satisfactory. But in terms of getting that legal advice, we will be able to give that to you if you do live in one of those two counties. Now, we do not have a requirement that you be a U.S. citizen. We are able to assist permanent legal residents and undocumented residents of San Bernardino and Riverside County. There are specific monetary guidelines for each of those different groups. So we do recommend you contact us so we can assess your specific situation. I think our top goal is to really provide high quality legal services without that expensive price tag that usually is associated with, having an attorney. We try to remain culturally sensitive. A lot of our staff speak Spanish. I think it's actually 90% of our staff is Spanish speaking, and we do have access to other translators in other languages. So if you or somebody else, somebody you know needs legal assistance, but is not able to speak English, we will be able to find somebody to translate for them and get them the help that they need. We generally do not offer courtroom representation, but as I mentioned, in those few select areas, we do offer full representation, but that's not our general service we offer. And of course, we do have a lot of sponsors and supporters, and these are some of our grantors that help us to provide free legal assistance. So by receiving funding from LSC, which we receive through Inland County Legal Services, from the United Way, from the City of Riverside, and from various other state funders, this is how we're able to provide services. So we do have to show them, meet their requirements by showing them, different records of, who we're serving. But ultimately, it does allow us to serve our clients for completely no cost. And then, of course, here's some of our contact information. So we do have our general email, which is just info@ayala.org. And then we have one specifically for record clearing services. So again, that's expungements, termination of probation, certificates of rehabilitation, and that's secondchance@ayala.org. And again, my name is Veronica Garcia. Here is our phone number. It's 951-369-3009. And it is open Monday through Friday from 8 to 4:30. We do have a guided voicemail that will allow you to leave a message for whichever department or division you're looking for legal assistance in. So you can always leave us a voicemail or again, send an email with some of your questions. And now I'd like to open up if there are any questions. And looks like I do see one in the question and answer section. So this was related to, can misdemeanors and felonies be expunged? And to answer that, yes, both of these can be expunged. So it's really dependent on what your conviction sentence is. So if you're sentenced to prison versus probation, that'll determine what type of relief you'll be eligible for. But both are eligible for expungements.
Veronica, there were some other questions that were in the chat. One is if this presentation will be made available after the event is over, the slide itself.
Oh, okay, perfect. So I can go ahead and send those to you, Jenna. And I'm not sure how you're going to post or distribute the slides, or I'm sorry, the PowerPoint, but I can definitely make the slides available.
Okay. And then there's some other questions. What areas does Ayala serve?
So geographically, that would just be anybody who lives in San Bernardino or Riverside County. Now, that means we can assist you with legal matters in other counties, but unfortunately not out of state. So if you are served with a divorce in Nevada, unfortunately, that would not be something we can assist with. It would have to be a legal matter within California. But again, that's anywhere. So most recently we filed, I think, expungements in San Jose. We responded to a divorce, also Northern California. So as long as you live in San Bernardino or Riverside County, then, and the legal matters in California, then you're good to go.
And then are your services available to undocumented immigrants?
Yes, they are. All of our services are. It just has a different income requirement. So we would just need to see what their assets and income is.
Okay. Is there a wait list for services?
Right now, it's a pretty short wait list. Like I said, we try to get service within about a week of receiving your qualification.
Okay. And it says, the question is you will not be able to provide a referral to someone who lives in Orange County but works in Riverside County?
We could give them a referral to another legal aid organization. Orange County does have some pretty good similar type offices. So they would be able to contact them and they'd likely receive assistance there since they do reside in Orange County.
Okay. And what would the income limit be for undocumented immigrants?
So we do go by the federal poverty guidelines. So generally it's 125% of that federal poverty guideline. So I can't give you a specific number, but you always, you can go to Google and it's something that is searchable.
So those are, I'm looking through the chat again. It looks like that was all of the questions, and it looks like another one came through the question and answer. Can you assist with power of attorney and will services?
That is actually something that right now we generally do not assist with. We are looking to expand our services into that area, but we can definitely refer you to other offices that are able to assist you. I saw another one, can you petition the court to reduce fines? So regarding that question, unfortunately, that would have to do more with an active criminal case. So that would not be something that we would be able to assist with. Something you can do, though, is obviously when you're applying, it would depend on if you're on probation or if you've already completed probation or if there was no probation granted. There are some ways that you can make that request, but unfortunately, we can't just do it directly if that's the only concern. Let's see, somebody else had a question relating to income based on the whole size of the household. So when you go through our intake, we do have a pretty extensive intake qualification list. You have to provide us all of your income and all of your expenses. And we do get into the specifics of who's in your household, who you provide support for, or whether or not you're considered an independent household, because so often we see, families live together, especially right now, especially in, with the high unemployment and, difficulty finding jobs. Sometimes we totally understand that, family members do live together, but maybe they're not considered the same household. Maybe you have two families that independently support themselves, but each contribute to the shared expenses. So we would look at those people that are considered within your personal household. And then relating to immigration, unfortunately, right now, we do not provide assistance with immigration. That's another area where if you contact us, we can give you some amazing referrals for people that would be able to assist you. And let's see, we have another question and answer. Do you provide presentations for teens on basic rights? Yes, that's actually something for our teen parent program. That's something that we normally would address it in schools. We arrange presentations through the schools. So we're going to try to figure out how to start reintegrating that into some of the options for teenagers and teen parents. But if you have something specific in mind, definitely send us an email. We can see if we can arrange something that would be specific to what you're looking for or what information you need. I think that's all the questions we have so far. So that'll just about wrap it up for me. I know we have a little bit of time in between the presentations.
Yes, so the next presentation starts at 11 and it's with Inland Counties Legal Services. So if people want to wait for that, they can, or if there's more questions, Veronica, are you going to stay a few?
Yes, definitely. I'll be here to answer any questions. And then I'll go ahead and get the slides ready and send them to you via email so you can post them wherever we end up posting the PowerPoint.
Okay, and just for all of the attendees,